given a request, which he said he now executed. He did a trajectory of the vehicles, which includes the vehicle that was carrying the deceased persons. And that I've already dealt with that, so I'll not go into that. Now, he testified that the investigating officers were also concerned to know whether any police radio phone registered activity within Mavoko locals, particularly in the hours of 1200 hours on 23rd of June 2016. And one radio fitted that description, which was the radio with ICDA number 359033304, which is Exhibit 25. Now, PW37 stated that on further query of the serial number, it indicated that the radio phone was captured at Syokimau Police Post at 12:20 hours to 12:40 hours. The radio phone was captured at Mlolongo Police Station between 15:20 hours and 15:40. The radio phone was later captured again at 18:40 hours, between 18:40 hours and 1900 hours at Syokimau Police Post. The radio was captured at isolated field mastermind area called Soweto between 1940 hours and 2000 hours. At around midnight, the radio is captured on the eastern bypass traveling towards Kangundo Road. It was again captured at Thika Superhighway at 0040 hours, between 0040 hours and 1 o'clock on the 24th of June. This is the same night. And then finally on the 24th, the radio was captured at Valley View Estate between 22:20 hours and 22:40 hours. That radio phone, Exhibit 25, according to PW20, the OCS Mlolongo, was IMEA number 864106020019873 and was issued to the in-charge SPIV, Senior Sergeant Leliman, who is the first accused in this case. PW20 testified that every radio has its own charger and that every office had a charger. PW20 testified that he issued the first accused with the radio, Exhibit 25, which he received together with its charger. The first accused stated that upon deployment from Athi River Sub-County Headquarters in Mlolongo Police Station, following his transfer from Turkana to the region, his boss, who was defense witness number 10, Commissioner of Police, issued him with a firearm, a bulletproof jacket, and a radio phone. The first accused gave its number as police number 559030101 and the IMEA number 864106020310076 and was Exhibit 5. Now, the first accused stated that it was that radio phone that is he and his SPIV team used for their work. He explained that he could not have given this radio phone to anyone else except Sergeant Mwangi, as the other officers were from the regular police, that since the fourth accused was proceeding on short leave, he went home with the radio. That on the 23rd of June 2016, the radio was at home. And that on the 24th June 2016, he left the radio charging at Mlolongo Police Station, crime office, when upon switching it on in the morning of 24th, he realized that it had no charge. Mr. Ombeta submitted that the police should have investigated the alibi of defense of the accused, given it was put forward early enough. For that proposition, he relied on the Nigerian case. And then he also he relied on the Kenyan case, Wangombe versus Republic, for the proposition that a prisoner who puts forward an alibi as an answer to a charge does not thereby assume any burden of proving that answer. It is misdirection to refer any burden as resting on the prisoner. In such a case, for the burden of proving his guilt remains throughout on the prosecution. Now, the prosecution has established that on 1st July 2016, when the first accused was arrested, he had the radio phone, which is Exhibit 25. He also acknowledged in his defense evidence that he was actually arrested with that radio phone. As shown above in the evidence of that PW-7, this radio phone, that is Exhibit 25, was captured in all the sites at the various stages in the sequence of the commission of the murders. It was at the posts at Syokimau, post at 12:20 to 12:40, when the deceased persons were delivered there and placed in the cells. It was captured again between 1840 and 1900 at the Syokimau post, the time the deceased persons were removed from the cells for Soweto open field. The radio was captured again between 1940 and 2000 hours at Soweto open field, where the murders took place. At around midnight, it was captured on the Eastern Bypass, traveling towards Kangundo. The radio was captured at the Thika Superhighway at 0:40 hours, which is the time of the return trip from Oldonyo Sapuk. PW-7 testified that the phone radio signals could be tracked within Nairobi area and towards Thika. The signal tracking ends around Juja, which explains the lack of tracking beyond Juja, both for the trip towards and trip from Kilimambogo. Now, under Section 111, subsection 1 of the Evidence Act, the first accused had to discharge a rebuttable presumption by offering a reasonable explanation about the radio phone Exhibit 29, which was tracked in all the lock-in quo, and 9 days later was actually found with him. I have considered the sworn testimony of the first accused. He stated that upon deployment from Athi River sub-county towards Mololongo area police station, following his transfer from Turkana, his boss, who was PW-10, issued him with a firearm, bulletproof jacket, and a radio phone. Now, the first accused gave its number as police number 55903101 and a mayor, which is Exhibit 35. Now, the first accused stated that it was that radio phone that he and his PIF team used for their work. He explained that he could not have given this phone, radio phone, to anyone else except Sergeant Mwangi, as the other officers were from regular police. That since the fourth accused was proceeding on short of the fourth, and that he proceeded to Makindu police station, but on the return he could not find it, so he grabbed the one that he found charging, which happened to be Exhibit 25. Now, what the first accused needed to give was a reasonable explanation of how he came to be found with P Exhibit 25, which had been to all the lock-in quo of this case, and yet he insisted the radio phone was not the one that had been issued to his team. His explanation is incredible for reasons. One, PW-34, the county commissioner, the county communications officer in Machakos, testified that on the 26th of April 2016, he issued new pocket phones to Athi River Division, which was to start using the new system of radios covering Nairobi area. His PW-34 testified that he indicated who should receive which specific radios. In Mulolongo, he said the specific pocket phones that each officer, that is the OCS, his deputy, and his PIF team, and the CID section, and Syokimau police post were to be issued with as per his register, which was Exhibit 73A. 2. PW-20, the OCS Mlolongo, confirmed that the first accused received the radio allocated to PIF team, which was Exhibit 25. And then 3, the radio Exhibit 36 had no data, and PW-37 testified that the reason for no data was because it was never used at any one time. Indeed, PW-44 and 45 and their team recovered it. At the time that they recovered it, it was in the house of the fourth accused. The radio was neatly packed in its box, complete with its wrappings and the nylon film used to protect the screen when it is new. It is therefore not true that the first accused, what the first accused said, that he and his team used that gadget for their work. Now, 4, after being in each of the 5 sites or lock-in core of the murders, the radio, which is Exhibit 25, was captured at Valley View Estate between 22:20 and 22:40 hours on the night of 23rd and 24th June 2016. Now, Valley View Estate is where the first accused, the house of the first accused was. So where he lived with his family at the time. And then 5, the first accused was carrying the radio, Exhibit 25, on the 1st of July 2016, when he was arrested at Flying Squad offices where he had been summoned. And lastly, since the first accused said that he was the one who had the radio, Exhibit 36, on the morning of 24th of June 2016, when he left it charging in the office, how did it get to the house of the 4th accused? In its box, wrapped as new, complete with the protective film on the screen, and yet the 4th accused was away between the night of 22nd of June and 27th of June 2016. How did it get to the house of the 4th accused? Now, the evidence of the police radio phone trajectory detailing the movement of the radio P Exhibit 25 on the 23rd of June and the evidence of its recovery from the first accused 9 days later all show that the first accused, as in charge of SPIV and in line with the accountability protocol of accountable gadgets like police radio phones, had custody of the radio phone and had used it exclusively at all the 5 lock-in quo at the time the offenses were committed. The prosecution proved that the radio issued to the first accused by PWD defense witness number 10 was never put to use. So I find that as the radio indicated, the first accused was at the Mlolongo police station on the 23rd of June 2016. He proceeded to Mavoko locals, then to Syokimau post, to Soweto later that evening, where the deceased were all murdered, and to Glimambogo through the Kasupa Highway to dump the bodies of the 3 deceased persons before returning to fetch his co-accused at his bar in Mlolongo for work well done. Now, I consider the first accused defense, the evidence of his witnesses. I find that the prosecution has established that it is the first accused who had the motive to harm the second deceased in this case, because as a result of the complaint he made against him at IPOA, his job was on the line. The first accused may have gone to Uhuru Camp to help his sister-in-law in the morning of the 23rd. However, from then on, the evidence is overwhelming that he personally attended to ensure that the deceased persons were captured, they were detained to await nightfall, they were murdered, and their bodies dumped or flung into the river to make it difficult to ever recover them. His explanation about the radio phone Exhibit 25, just as his alibi defense, is unreasonable, incredible, and is not plausible, and therefore I reject it in total. I have carefully considered the entire evidence adduced in this case by both sides, and I have considered the submissions by counsel the authorities relied upon, and having done so, I find that the circumstantial evidence established against the first, second, third, and fifth accused persons justify the drawing of an inference of guilt to the exclusion of any other reasonable hypothesis except that of guilt. I considered whether there were coexisting circumstances that could weaken the chain of the circumstances relied upon, and found none. I am satisfied that there was no other reasonable hypothesis that can be made on the basis of the evidence before me except that of guilt. In the result, So in the result, I find that for the fourth accused, his alibi defense has shaken the veracity of the evidence of the prosecution against him, being that of the fifth accused alone, and therefore I gave him the benefit of the doubt and acquit him of all the 3 counts of murder under Section 322 of the Criminal Procedure Code. For the first, second, third, and fifth accused, I'm satisfied the prosecution has proved the case against them beyond any reasonable doubt, and therefore I found them guilty of the 3 counts of murder, contrary to Section 203 of the Penal Code. I accordingly reject their defenses, find them guilty as charged, and convict them accordingly under Section 322 of the Criminal Procedure Code. Now, I also want to inform the first, second, third, and the fifth accused persons that they have a right of appeal within 14 days from today. And before I end, 2 things. I wish to register my gratitude to the Learned Prosecution Council, the Learned Councils for the defense, and the Learned Councils for the victims and the interested parties. And I thank you very much for your great support, your industry, and contribution to jurisprudence, and also for giving me an opportunity to complete this case. And I also thank the accused persons for allowing me to complete the case. At the beginning, it didn't look like it was going to happen. Now, I wish to end with a little story. There's a man who told his son that he wanted to teach him a new trade. So he asked him to follow him. They went to the neighbor's farm and stood next to a mango tree. The father told the son to look around as he climbed up to pluck some mangoes. He told him that his role was to look around, and if he saw anyone at all, to start running home, and his father would follow him to avoid arrest. So the young old man climbed the tree. After 5 or so minutes, the father saw his son running, so he climbed down quickly and followed him. After running for some time and seeing no one following them, the father stopped his son and asked him why he ran, telling him that he did not follow his instructions. So the son said, "No, but I did follow your instructions. I looked up and I saw God looking down on us, so I ran away." So that is the end. Now,
Thank you, Someshi. Before sentencing, we should be on record.
now I'm totally funked as official. I want to make only one order. To take this, to have this file placed before the presiding judge criminal, so that you proceed with the other things. What did you want to say?
Obviously, before the sentencing, we wanted to inform the court that the 4 accused persons are first offenders.
No.
But we'll do it before the other court.
Not even that. I think we also need to have victim statements,
yes,
victim impact statements, and things like that.
And of course, we wanted to request there can be also confession of charges before the sentencing.
Tell them to stand.
Ladyship, we requested we have an issue that you've raised. Your Ladyship has said that your predisposition is that
the other aspects, including sentencing, should go probably to another judge. On behalf of the third accused, Your Ladyship, we would have preferred that you complete the process. Yes, we want to be on record as saying that, Your Ladyship.
I thought you said coram non judice.
I think I'll be taking the same position with my learned colleague, because again, also having had your judgment and another judge coming in to give the sentence, putting into consideration that you said the second accused person gave unsworn evidence, yet we know clearly that he gave sworn evidence. How will that be handled? He gave sworn evidence, he was cross-examined. In your ruling, the whole judgment is that he gave an unsworn statement. From this particular point onwards, you can see why you want to appeal and why we're having a problem with your judgment.
I don't know what you are saying. What are you saying? Are you saying I hear this, I do the sentence, or are you saying...
Yes, you let us go to the end, because you see, the moment you have said that my client gave unsworn evidence, yet we all know that he gave sworn evidence and he was cross-examined. That puts us in a position whereby, first of all, we are saying that probably the new judge who comes in to do the sentencing must look at that as well. You having then given the judgment with this very serious omission or problem that you have created, do you shift this burden to another judge, or do you do it by yourself? Because for me, it is pretty serious that you did then not get the evidence of a second accused person you have convicted him, yet he gave sworn evidence. It was cross-examined by everybody, but according to your record, it was unsworn. How did this come about? So these are issues that we will raise, probably maybe even in the next judge, but I'd rather that you are there so that we can throw these rocks at you.
Your Ladyship, the whole idea was mine. I just want to dissociate myself from what Cliff has said, Your Ladyship. Your Ladyship, my point is this, Your Ladyship. I'm not taking the same militant position as Cliff is taking. My point is this, Your Ladyship. Sentencing is the point at which a judge is most subjective. It is the point at which the judge is applying consideration of all the issues that are obtained since the start of the case. And for that reason, Your Ladyship, if there was any role you would have played, it is more at sentencing than at any other point. And for that reason, Your Ladyship, I'm making more informal request, Your Ladyship, that you do, having come this far, that you do entertain the process up to the point of sentencing.
No, but somebody wants to throw things at me, so why do I want to sit around to wait for missiles to be thrown?
But who else can do that? You see?
Now I think, let's hear Mr. Michuki.
Yes, because even when you place the radio in the second accused's hands and you read it in your judgment, we have a problem, don't we?
Your Ladyship, just 2 points. First, I'd like to associate myself with my senior, Mr. Carter. I think sentencing is an exercise of discretion, which you have to take a number of factors, and a new judge does not have a grasp of this matter to every sentence the accused persons or not a convicted person. Secondly, my lady regards to the seeker indulgence that he continues being held at Naivasha under the protective circumstances. He has been held since he took plea in this matter. Yes, separating from the other accused persons has always been the case. Lastly, off the record, given that my deliberation fall squarely upon you, my lady. I would wish for you to proceed. Please.
I thought you are the one who is very sure I'm quorum non judice.
Your lady, you already accept jurisdiction. I will follow you. I'll follow your decision. We cannot give any other issues on appeal.
Your Lordship, on behalf of the court accused, we can only say thank you. It has been a long journey.
My lady, on behalf of MSK and of course the victims, sorry, Mr. Chair.
Yes, on behalf of the court accused, we are also requesting that his mobile phone unit has been found, be restored to him. And also, on behalf of the pastor accused, only for plan and council, Mr. Cliff, on better, is requesting that his car be released.
Who's car?
The first accused car.
There was not a vehicle that was used as an exhibit that was detained. We had that argument and the state had said that they wanted to vote on it. You had made a decision that you would, at the end of the trial, make a decision about it. There was not a vehicle that was used as an exhibit. It was KB 959 something. Yeah. It's so long we have all forgotten about the number plate. But it's in the court.
I don't know what I'm releasing. Does it have an exhibit number?
I noticed it's a KBF 959H. It was a Winroad Nissan. KCG 959H. It was a Nissan Winroad white in color. No, second color.
That's not the one you released to the wife of the first accused. It's not the one.
Nothing was released.
K what?
KCG 959H.
Yes. Anyone else?
My lady, on behalf of the victims in their entirety,
Yes, just 1 minute. Just 1
the
minute.
family and their wife, let's pray. We would also wish to file a victim impact assessment, 329C of the CPC, and we are seeking 14 days and we are putting this victims in their entirety.
So when you say law society, how many statements am I going to get? Or will be filed?
Pardon?
You are saying the entire law society, so I don't know how many statements.
Let me just two statements, but covering the victims in their focusing on the SK and the victims in terms of the family.
also was an operative process. Things or something technical to do.
My lady, I think when first I stood, I was cut short before I completed my statement.
Yeah, because I wanted to adjourn, but other people have now said other things.
Yes, now that we proceeded, allow me to say this. First of all, that the 4 accused persons, 1, 2, 3, and the 5th, we have no previous records of conviction.
We are not taking any mitigation at this stage.
Okay, I'll say that later. Then, really, my view is that a court that convicts is the most appropriate sentence. And we require 2 weeks to have the statement, that is the impact statement. We have filed only 3 in relation to the deceased persons. Put in place for your consideration. We also urge you to exercise your discretion and order for professional class report in respect of the 4 accused persons to be filed and shared with the prosecution before the sentence is closed. These are our 2 prayers today. The issue had been raised by a motor vehicle, which was produced by the prosecution, which belonged to the spouse of the first accused. And the motor vehicle that was used to ferry the deceased person's bodies to the lady. We have not come to the conclusion of this matter. We only have a conclusion, and it would be premature. My understanding and the interpretation of the law to come to this matter now. But when we come to it, we want to address ourselves substantially, because as we indicated when there was an attempt with the release of the motor vehicle, we did indicate that this was an instrument of crime which is subject to confession, which are considered orders of court. So I don't want to go into it.
You are saying subject of what?
Confession. And I don't want to go into this because we want, after the conclusion of this matter, to address the issue of substance where we had. And if need be, we file our submissions in the matter, in the respect of the release. That is all we need.
My lady, in this motor vehicle, we had a problem about it. Initially, at the close of the prosecution case, and then after the defense case, and now a creation is being made that is subject to forfeiture. That does not exist on any law.
No, I'm not.
My lady, the only thing that exists on forfeiture is known. It's either things to do with drugs and lots of things. In murder cases, let him not create this law. It's not there. Let him just release the motor vehicle. I don't know what interest they have on this motor vehicle on the 3 stages that were made this application. It does not exist. If it does not exist, then your leadership can't even give him time to make an application about it. It doesn't exist.
No, I will not consider that one for now. I think if their indication is they want to make submissions, then we can hear, but both sides can be heard. Yes.
Your Leadership, I just wanted to seek a copy of the judgment of the court for now. To go on record that we'll get it proposed. Your Leadership, you know, and the proceedings certified for purposes of appeal.
The proceedings are there. I thought you have been getting all of them.
They're not certified, Your Leadership.
Now I'm funked as official. You will talk to the DR. So is this?
Ladyship, we have a request also for the third accused. Your Ladyship, in view of what the prosecution has said and the victims, Your Ladyship, we would pray that the victim impact reports, Your Ladyship, be designed in a way to make reference to specific accused persons, Your Ladyship, rather than general contention on the part of the victims, Your Ladyship. And we still plead with you not to step out, Your Ladyship.
No, I think I've had enough. I should just step out of this matter. Don't you think? Now, do you want to give a written mitigation?
For the first accused person, I prefer that I do it orally.
For the third, Your Ladyship, we propose to write it in writing. And Your Ladyship, we would like clarification whether our 14 days start running today or after you do the sentence.
Your Ladyship will also do as in writing, but we will seek to do a mitigation post-service of the victim court report and the pre-sentencing report. Yes. Secondly, on the issue of the appeal, I think maybe I can use that to seek to ask you to continue sitting in this matter. We have a situation where there's an issue with the sentencing, we have to file out to appeals, one in conviction, one in sentence. Maybe.
There's nothing like that.
That is the situation we'll be creating. We'll be creating new jurisprudence.
Now, the vacation is coming, so I don't think anybody will be able to sit during vacation. Which is the date next?
Vacation will end on 15th. Vacation will start to end on 19th.
Can you take 23rd of September for the mention?
That's okay by us, and it should be followed.
That will be decided later. I'm not based in Nairobi, so if I'm not facilitated, I'm not coming back. So the orders are that the case is adjourned and with the following orders. So the first, second, third, and fifth accused persons will remain in custody pending the sentence in their respective prisons. There will be probation officer's report on the accused persons. That is the ones who have been convicted, and there will also be a victim impact statements, limited to 5 because we want from the victims, the deceased, and then maybe the other victims, only 2 others. And this report should be shared across the board. And then the case will be mentioned for receipt of those reports and also for further directions on 23rd of September 2022.
Already, on behalf of the bar, the Law Society, and all the council present,
Just identify yourself for the record.
yes, my name is Willy, President of the Law Society of Kenya. I wish to place on record the gratitude of the Law Society and its members to the court, to the Prosecution Council, to the Defense Council, to the Victims Councils, and particularly to Council representing the Law Society, Professor Sihanya, Mr. Ongaro, for the industry in which they have represented their respective clients before this court, and for the manner in which this court has conducted the proceedings. Willy, Kimani was a crusader against police abuse of authority, and he unfortunately met his death in the course of that crusade.
and it is largely due to the work of his fellow Crusaders that today this court has delivered a very significant judgment and really the significance of this judgment is a demonstration of the triumph of justice over impunity, and it reinforces our belief in the administration of justice and the rule of law. But the decision is also significant in the fact that it cements the place of use of technology in investigating and prosecuting criminal suspects. Today, this court has struck a bold strike for the rule of law in the administration of justice. And I really thank you for that. Finally, before I seek my lady, allow me to recognize the family of Willy Kimani and his two other deceased, Joseph Mwena and Joseph Willy. But the family has consistently attended this trial, except perhaps during the COVID period. They have demonstrated in their coming to this court every day their utmost belief in the ideals for which Willy Kimani died for. And I want to commend them for their bravery, for their fortitude, and to say to them that Willy Kimani did not die in vain. And this judgment is a testament to that. And all the members of the Law Society reinforce the creed that they have always made. I am Willy. Thank you, Willy.
I think with that I say thank you very much. I can see we had an overflowing crowd. I wish you all the best, whether I come back to the case or not. I wish you all the best. And the court is adjourned. In the rough draft.